They handed me the termination letter at exactly 4:47 p.m. on a Wednesday. The time stuck with me because everything about the moment felt calculated. Late enough that most people were already mentally gone for the day. Early enough that security was still present, perfectly inconvenient. Grace Stevens from HR slid the folder across the conference table without meeting my eyes. Owen Ashford sat to her right, hands folded, posture straight, the posture of someone who had already emotionally left the room. "Marin," he said, clearing his throat, "we need to discuss a serious matter regarding your performance." I looked at him calmly. "What performance issues?" "Multiple stakeholders have raised concerns about your operational effectiveness," he replied, reading from prepared notes. "After careful review, leadership has determined your performance no longer meets Apex standards. Your employment is terminated effective immediately. No specifics, no examples, no metrics. 14 years at Apex, and that was it." "I'd like to review the documentation supporting those concerns," I said. Grace cut in quickly. "That won't be necessary for this meeting. What's important now is your transition. We're offering a separation package if you sign today." She pushed the folder closer. I didn't touch it. Instead, I opened it slowly and began to read. They sat in silence while I read all 28 pages. Every clause, every subsection, every footnote. 35 minutes passed. Owen shifted in his chair. Grace checked her watch twice. The severance was standard. 18 weeks of pay, health insurance through March, non-disclosure, non-solicitation, nothing generous, nothing insulting. But something was missing, very missing. Still, I signed, every page initialed, every signature line executed, my full legal name written carefully each time. Marin Elizabeth Holt. I stood, gathered my bag, my notebook, the framed photo from my anniversary trip with my husband, and walked out without another word. No escort, no goodbye, no apology. By 11:23 p.m., the termination package sat on my dining room table. 3 identical copies, each one signed. I poured a glass of water and read it again. That's when I saw it clearly. Section 7, subsection C, buried on page 9, in cases where termination results from documented performance deficiencies. This agreement shall incorporate by reference all performance improvement plans, warning notices, and evaluative materials relevant to said deficiencies attached herein as Appendix B and forming the factual basis for separation. I stared at the page. There were no appendices, none. I knew that language intimately. I had written it myself 4 years earlier when I'd been promoted to Vice President of Strategic Operations and tasked with overhauling Apex's HR policies. I'd insisted on protections, documentation, evidence, due process, because I'd seen too many careers destroyed by vague accusations, and now Apex had just fired me for consistent performance deficiencies without attaching a single piece of documentation. At 2:13 a.m., my phone erupted. Unknown number, Boston area code. I let it ring, again, and again. Finally, I answered. "Marin Holt speaking. Miss Holt, this is Liam Callahan, Senior Counsel for Apex Dynamics." His voice was tight, unsteady. "I apologize for the late hour, but I need to ask you something urgently. Please tell me you didn't actually sign the separation documents." I smiled in the dark. "I signed exactly what your HR director presented to me." A long pause. "There may have been a documentation oversight," he said carefully. "We'd like to discuss revised paperwork." "What sort of oversight?" I asked. "I'm not at liberty to discuss specifics over the phone." "I executed all documents at 7:15 p.m., I replied evenly. "They were scanned and sent to HR by 7:38. "Is there a problem with your documentation?" Silence, background voices. Someone was panicking. "Miss Holt," he said finally, "the agreement should have included appendix materials." "Should have?" I repeated. Interesting choice of words. I turned to page 9. Section 7, subsection C, I said. Performance-based terminations must include performance improvement plans attached as Appendix B. Another pause. "I received no appendices," I continued. "Which means either this wasn't a performance termination, or your agreement violates your own policy." Dead silence. "Either way," I said softly, "I believe we'll be seeing each other in court." I ended the call. My husband Elliot stood in the hallway, having heard everything. "You planned this?" he asked. "I planned for the possibility," I replied. "I wrote those rules for a reason." That night, Apex Dynamics realized something they hadn't considered. They hadn't just fired an executive. They had fired the person who knew exactly where the cracks in their system were, and how to prove they'd stepped right into them. By Thursday morning, the panic had fully set in. At 8:14 a.m., an email landed in my inbox. "Miss Holt, following our conversation last night, Apex Dynamics would like to meet to discuss revised separation documentation addressing certain procedural oversights. We believe this will serve both parties' interests. Can you be available Monday at 10 a.m.? Liam Callahan, Senior Counsel." I forwarded it to my attorney, Elizabeth Rains. Her reply came less than 10 minutes later. "They know they messed up," she said when I called her. "And now they're trying to fix it after the fact." "Can they?" I asked. "No, not cleanly. You already signed. Either the agreement stands, and they violated their own policy, or it doesn't, and your termination is invalid." "So we go?" "Absolutely. And I'm coming. With you." Monday morning, we arrived at Apex's headquarters at 9:52 a.m. Same building I'd helped design operational flow for. Same lobby where my badge had once opened every door. Now I was a visitor. We were escorted into a large conference room. Waiting for us were 3 lawyers and 1 executive. Liam Callahan sat stiffly at the head of the table. Beside him was Nolan Schwartz, outside counsel, mid-50s, corporate calm. Across from them sat Diane Kelton, Apex's CFO. "Too many people for a procedural oversight." "Miss Holt," Liam began, forcing a polite smile, "thank you for coming. We believe we can resolve this constructively." "I'm listening," I said. Nolan tapped a tablet and slid it across the table. "We've prepared revised separation documentation," he said. "This version includes the performance improvement materials that should have accompanied the original agreement." I looked at the screen. 4 documents. All created after my termination? I asked. "These reflect concerns previously communicated verbally," Nolan replied. "They're now properly documented." Elizabeth leaned forward. "Performance improvement plans don't work retroactively," she said calmly. "You can't document justification after the termination decision has already been executed." Nolan didn't respond directly. "The documentation reflects performance patterns," he said instead. I began reading. Document 1, Colin Reeves, failed to meet efficiency targets. Which targets? Which dates? Which metrics? None specified. Document 2, Ava Pierce, poor judgment in budget meetings. Which meeting? Which decision? Which budget? Nothing. Document 3, Harold Brennan, resistance to new methodologies. I stopped. "Harold Brennan hasn't worked at Apex for 5 months," I said. The room went quiet. "He provided observations based on his time here," Nolan said. "He left before Owen Ashford even joined," I replied. "He has no knowledge of my performance during the period you're claiming justified termination." Elizabeth was already typing. "You're relying on testimony from someone who wasn't present during the relevant time period," she said. "That severely undermines the credibility of this documentation." Nolan shifted. Diane Kelton finally spoke. "Miss Holt, perhaps we can approach this practically. Apex is prepared to offer enhanced severance, 30 weeks instead of 18, extended benefits for 24 months, mutual release, no litigation." I looked at her. "You want me to accept fabricated documentation in exchange for money?" "We want closure," she said carefully. "What you want," I replied, "is to cover a policy violation." Silence again. Elizabeth stood. "We'll review your offer and respond within 72 hours. We left at 11:17 a.m. In Elizabeth's car, she smiled. "They're terrified. What makes you so sure?" "They tried to move past the Harold Brennan issue too fast. That's desperation. And desperation leaves trails." Over the next 3 weeks, her firm followed those trails. Former Apex employees, public records, pending complaints. The pattern was unmistakable. 34 performance-based terminations in 4 years, 23 required documentation. Only 6 had it. The rest? Quiet exits, signed agreements, careers erased, and almost every termination followed the arrival of a new executive. Then we found Owen Ashford's history. 3 wrongful termination suits at his previous company, 2 settled, 1 verdict against the employer. This isn't random, Elizabeth said. This is a playbook. Then came the emails. Internal, subpoenaed, unfiltered. Subject line, Q4 cost reduction strategy. My name listed with my salary. Cleanest termination path? Grace warned about policy requirements. Owen dismissed them. Get statements. Move quickly. I stared at the screen. It was never about performance, I said. No, Elizabeth replied. It was about money. We amended the lawsuit, added fraud, added punitive damages. And that's when Apex stopped pretending this was just a misunderstanding. Because now, it wasn't just a wrongful termination. It was proof they knew the rules, and broke them anyway. Once the amended complaint was filed, everything changed. The tone of Apex's legal team shifted overnight. No more casual emails, no more talk of procedural oversights. Every message was marked confidential, every phone call carefully scheduled, every word weighed. They knew. Those emails were lethal. Emails don't forget. Emails don't get nervous. And emails don't lie. The first serious settlement offer arrived 2 weeks later, $3,200,000. No admission of wrongdoing, strict confidentiality, immediate dismissal of all claims. Elizabeth slid the printed offer across her desk. They're trying to buy silence, she said. And? I asked. And it's not enough. We countered at $4,200,000. Apex came back at $3,600,000. We countered at $3,900,000. They accepted. The final settlement was signed in June 2025. It included terms Apex had sworn they would never agree to. A $3.9 million payment. A written admission that my termination violated company procedures and should never have been classified as performance-based. No confidentiality clause, not partial, not limited, none. Mandatory revisions to Apex's termination and cost reduction policies, third-party audits of past performance-based terminations, mandatory employment law training for all executives, and a personal letter of recommendation signed by the board of directors. That admission was everything, because once it existed, others could use it, and they did. Within 3 months, 6 former Apex employees filed lawsuits citing the admission. Every case settled quietly. Every settlement cost Apex more money. The final tally? Over $11,700,000, all to save $2.3 million in short-term costs. Corporate math has a way of humiliating itself. 7 months later, I received a call from a former board member. Owen Ashford has resigned, he said. HR has been completely restructured. The audit uncovered 17 policy violations. We created a remediation fund. How much? I asked. Nearly $6 million. I ended the call and sat in silence. I hadn't just won a case. I'd exposed a system. The aftermath wasn't glamorous. Some doors closed. Recruiters went quiet when they learned I'd sued my former employer. A few executives labeled me difficult, litigious, high risk. That was the cost. But something else happened too. People started reaching out, quietly. Privately, stories that sounded disturbingly familiar. Fired for attitude issues. Dismissed for cultural fit. Terminated for strategic realignment. No warnings. No documentation. No chance to respond. I realized my case wasn't rare. It was typical. So I stopped chasing titles. Instead, I started consulting. Teaching companies why policies matter. Why documentation exists. Why shortcuts destroy trust and cost millions. I titled my keynote presentation the 11.70 million email. It sold out, because every HR director in that room understood one thing. Policies don't protect companies. Following them does. The lesson isn't complicated. Read what you sign, look for what's missing, and remember, rules only work when someone is willing to enforce them. For Apex, ignoring one appendix cost millions. For me, reading carefully changed everything. And for 17 other employees, it meant justice they never expected to see.